The pure theory of law is likewise another jurisprudential view as regards the emanation of law and what exactly law is according to another writer entirely. Now, the pure theory of law was developed by a man, Professor Hans Kelsen. Now, Hans Kelsen, in his legal reminiscence, viewed law as a set of norms that has been accepted in a society. Now, this set of norms are accepted as binding on members of a particular society. Now, what is very distinguishing about this particular school or this particular theory of jurisprudence is that Hans Kelsen, in his legal reminiscence, opined that these norms trace its validity to a higher norm, which in turn traces its validity to another higher norm, which in turn traces the validity to another higher norm. According to Hans Kelsen's opinion, now, he largely departed from the positivist point of view as regards what law is. And in his own opinion, he said, the law is a set of norms that is accepted by members of a particular society or community as binding on them. Now, these norms that are binding on them take or obtain its validity from a higher norm, which also obtains its validity from another higher norm. So when we take a critical look at the pure theory of law as propounded by Hans Kelsen, so it is very important to see that Section 315 of the Criminal Code Act provides for the offense of murder. Now, murder is unlawful because it has actually been traced to the provisions of Section 315 of the Criminal Code. In turn, the Criminal Code obtains its validity because it has been enacted by the legislature, and by virtue of Section 4, the legislature is the body empowered to make law for the order, peace, and good governance of the Federation. It is also very important that the legislature's power to make law is valid, like I said, because it is provided under Section 4 of the 1999 Constitution. More so, this also gets its validity from a higher norm, in that the Constitution is valid because it originates from the people and it is accepted by the people as binding on them, as seen in the preamble to the Nigerian Constitution. We, the people of Nigeria. In essence, according to Hans Kelsen's own opinion and views, law is simply a set of norms, behaviors that are common, acceptable, and binding on members of a particular society or members of a particular community. He, however, expressed his opinion that this norm traces its validity to a higher norm. The higher norm traces its validity to another higher norm. The higher norm, in turn, traces its validity to another higher norm, which in turn gets its validity from the mother of all norms, which is referred to as a ground norm. Now, it is important to know that this theory of law is not without its own criticism likewise. And one of the criticisms that has been levied against the pure theory of law is that it is primarily concerned with the validity of a norm being traced to a higher norm. The pure theory of law does not presuppose or is not particular about the effect, the morality, or the immorality of a particular law. It is, however, concerned with whether or not the law can be traced to a higher norm, or whether or not there is a chain of connection between a set of norms. So one of the criticism, as I have mentioned, is that it does not preoccupy itself with the effectiveness of the law, the validity of the law, or the invalidity of the law. It likewise is primarily concerned with the legal connection that exists between a set of existing norms. There is likewise other criticism that has been levied against the pure theory of law. And one of the other criticism that is levied against the pure theory of law is that in certain situations, it is not easy to trace the ground norm in a given society. Why? Because the assertion that the constitution is the ground norm is simply based on a false logic. It is simply based on a false logic, not an identifiable and easily verifiable logic. Because it further brings up questions that if the constitution is the ground norm, then who created the constitution? The people. If the people put the constitution in place, then who put the people in place? This breeds questions on and on. So the idea that the constitution, in essence, is the ground norm is not easily traceable because it is simply based on false logic of the legal connection that exists between a chain of norms. So it is also very important to note that another criticism that has been levied against the pure theory of law is that it can only be said that the constitution is the ground norm when there is an existing faith in the legal order. In essence, in a situation where there is a military takeover in a country, so it is easily noticeable that the first thing the military does is to suspend the constitution, although it is often believed that the law sometimes sleeps but never dies. In essence, the military suspends the provisions of the constitution. After having suspended the provisions of the constitution, a question thereby pops up, which is, can we still insist in such situation that the constitution is the ground norm? No. Why? Because the constitution has been laid to rest. Summarily, this particular criticism against the pure theory of law states that the constitution can only be said to be a ground norm when there is an existing faith in the legal order that has been put in place. However, in a situation where there is inconsistency or breakdown in the legal order, the idea of the constitution being a ground norm ceases to be so. It ceases to exist, which thereby poses a major threat to Hans Kelsey's own opinion on what law is.